So,
Welcome to the Fragmented Whole, where we piece together the news and self. I'm your host, Amarachi Anakaraonye, and I'm honored to share this weekly podcast series with you. I want to make it very clear that protests for the removal of Silent Sam have occurred for decades and have heightened over the past few months due to the events that occurred in Charlottesville, Virginia. The third narrator that enters this episode is attorney Erika Wilson, an associate professor at the UNC School of Law and advisor of the BLSA. Attorney Wilson has served as faculty at the School of Law for over 5 years. In addition to Jasmine, I also spoke with Attorney Wilson about UNC's claims about legal ambiguity regarding whether or not they could legally remove the statute. She first provided me legal insight on federal legal options UNC administrators could assume.
federal law prohibits this university or any university from creating a racially hostile environment. And so the presence of a Confederate statute of a person carrying an armed rifle that historically has been meant and used to terrorize African American students would certainly meet the legal requirements for creating a racially hostile environment. So, as a matter of law, I don't see any barriers to the extent the university is alleging that the state statute prohibits them from taking it down. It's a basic principle of our legal jurisprudence that the federal law trumps the state law here, and that no state law that conflicts with the federal constitutional obligation can prohibit them from acting. I guess as a matter of law, the other issue is if the university truly believes that the state statute prohibits them from removing the statute, then the thing to do would be to go to federal court and ask for a declaratory judgment in terms of what their rights and obligations are with regard to the statute. That seems like a pretty straightforward thing to do. If I were in an administrator's position, I had some question about my legal obligation, I would probably go and get some opinion from a court in terms of what it is that I could or could not do.
For those of you like me who don't have a clue what a declaratory judgment is or don't have a legal background, I've got you covered.
So it means that you are asking the court to say what the law is or who. So in this instance, I guess the best concrete example I can give, let's take it outside the context of this statute issue. Let's say that you have an employee who alleges that they are being discriminated against by their employer. The employee sues, and so the employee can ask for the court to issue a judgment declaring that the employer's actions did discriminate against them. So it's the same concept here. The university could go to court and ask the court to say, whether or not the continued presence of the statute violates federal law, or whether or not the state statute prohibits them from taking down the statute.
In addition to providing federal legal options, Attorney Wilson also provided insight on state legal options UNC could take in determining their legal obligations.
You can also go to a state court and ask what their obligations are under that state statute. They can also petition the Historic Commission if they really believe that that is the route they have to take. Then it seems like if their position is that the state law bars them from doing anything, that they are really attempting to comply with state law. If they really had a desire to take down the statute, the other thing is that they could do is petition the Historic Commission to have it taken down.